Ms Maguire.
Thank you, Presiding Officer. I move my amendments 35, 38, 43, 44 and 45. In moving these amendments, I am thinking of victims of men's violence, women in all their diversity. I want to mention Anne, who wrote to me, along with the other females who offered to share their experiences with the Equality Committee in order to explain the importance of single-sex spaces. Space is important for their emotional and therapeutic needs as they recovered from the abuse exacted on them by men. I am heart sorry that the narrow scope of this bill has meant that the very important impacts of opening the process to a wider cohort have not been given as full an airing in our Scottish Parliament as they should have been. Presiding Officer, the purpose of these amendments is to prevent a person with a history of domestic abuse from obtaining a GRC without undergoing further scrutiny before a GRC is granted, and to ensure that GRC holders cannot take advantage of a change of identity to evade checks made under the disclosure scheme for domestic abuse by requiring a specific check on whether a person has a history of domestic abuse before granting a GRC, and if the application is granted, notifying Police Scotland. This would be achieved by requiring a specific check on the person's history. If so, the Registrar General would take further advice on whether to accept the application, with regulations to set how that should be done and permitting the involvement of such external specialist input as deemed appropriate. Domestic abuse is widely understood to include manipulative and coercive behaviour. These amendments are about perpetrators of that crime. I will.
Tess White.
Hi. Does the member agree with me that whilst we do welcome her amendments, there are still far too many loopholes in this legislation that need to be addressed in order to protect women and girls?
Ruth Maguire.
I thank Tess White for that intervention. I think we have to deal with the amendments that we have here. I do have concerns, so I would share concerns. My amendments are about the perpetrators of domestic abuse. Individuals who do this may be attracted to an easier access GRC process, specifically as part of a pattern of coercion of an existing partner, or to aid concealment of their identity to new ones. Some may see adopting a female persona as a way of gaining women's trust, and see being able to show that they've taken this all the way to obtaining a GRC as part of obtaining that trust. Now, there are routes for an interested person to challenge that a GRC was falsely obtained after the event. However, I'd ask colleagues if we could, for just a moment, put ourselves in the shoes of a woman who's been subjected to coercion, control and abuse. In doing that, I think we can acknowledge just how stressful it would be to engage with that process. And further to that, abusers may, as we occasionally see with custody and family courts, indeed see engaging in them as an extension of the patterns of control. These amendments aim to stop perpetrators of domestic abuse being able to do just that, and I commend them to the Chamber.
Thank you, Ms Maguire. I call Maggie Chapman.
Thank you, Presiding Officer. Very briefly, I will not be supporting any other amendments in this group. It is very galling to have to, again, make the arguments that predatory men do not need a gender recognition certificate to abuse women, and that trans people should not be considered and treated as a threat or a risk to others. The Disclosure Scotland PVG system, yes.
Ruth Maguire.
I thank Maggie Chapman for taking the intervention, and I wonder if she would acknowledge that she is the only person in here that's conflating trans people with criminals. The only person who's mentioning it. My amendments are about predatory men, not about trans people.
Maggie Chapman.
That is not the case. We have heard people... That is not the case. We have heard people in this chamber and in committee debates and elsewhere make exactly that conflation. The Disclosure Scotland PVG system is about giving employers the assurances about those they employ to work with vulnerable groups. Applying for a gender recognition certificate has nothing to do with applying for jobs working with vulnerable groups. We should not be using these mechanisms in this way, and I urge colleagues across the chamber to vote against these amendments. Thank you.
Maguire.
Thank you, Presiding Officer. I move Amendment 34. These amendments ask for more protection at the start of the process for vulnerable adults and require the Registrar-General to have regard to the Adults with Incapacity Act, as well as the importance of inclusive communication and promotion of equality and non-discrimination, by ensuring that information and support provided is done in a way that supports capacity and decision-making in line with principles of the Adults with Incapacity Act. The amendments would also require information, advice and support in relation to understanding the effect and consequences of obtaining a GRC, including for people who may have powers under a welfare power of attorney or guardianship order. The Adults with Incapacity Act is the key legislation that enables other parties to make decisions for people who do not have legal capacity to make the decisions for themselves due to a mental disorder, which may include mental illness, learning disability or personality disorder, or cannot communicate because of a physical disability. The person is considered incapable if they cannot act, make a decision, communicate a decision or understand or retain memory of a decision. As an experienced mental health officer told me, it's important that incapacity is not seen as a blanket judgment, but rather decision-specific. For example, you can have someone who can still manage their money but can't decide on welfare matters. I acknowledge that the bill provides ways for a person with an interest to challenge a GRC, but there's nothing included at the front end of the process. The committee made some general comments about the need for guidance for all applicants, looking mainly at 16 and 17-year-olds, but the situation of vulnerable adults didn't seem to be considered. A general duty in this area would prevent their needs being overlooked. For those covered by formal arrangements, a stronger provision is possible than for those without. The aim of my amendments is to build safeguards at the application stage to reduce the risk of a later successful challenge in the Sheriff Court on grounds of incapacity to understand. I will.
Sue Webber.
Thank you. I thank the member for taking my intervention, and I agree with Ruth Maguire that it is vital that only adults who are capable of understanding the implications of the decision are able to apply for a GRC. But does she also agree with me that this highlights that any application for a gender recognition certificate should only apply to those who are aged 18 or over?
Ruth Maguire.
I do personally agree with that, yes. Early assessment would prevent the person getting a GRC and then others having to intervene at a later stage. I believe that going through the process, then having it challenged at the end, would be far more difficult and challenging for the adult concerned. I want to be clear that this is in no way suggesting that everyone with communication difficulties or a learning disability would lack capacity. And I repeat that it's important that incapacity is not seen as a blanket judgment, but rather decision-specific. I believe these amendments will benefit applicants incapable of understanding by reducing the risk that they're put through complex and stressful legal processes that could have been avoided by taking more care earlier to avoid a GRC being issued to anyone incapable of understanding its effect. Presiding Officer.
Thank you, Ms Maguire. I now call Pam Duncan-Glancy.
Thank you, Presiding Officer. I wish to speak against Amendment 34 in the name of Ruth Maguire, but I do support Amendment 46 on the basis that I think it is incredibly important that we take into consideration inclusive communication and support for disabled people. I worry that the Amendment 34 could have a disproportionate impact on disabled people. For a number of years, guardianship orders and power of attorney have long since had an impact on disabled people's choice, control, freedom and dignity. And it is, of course, crucial that in this process, all, including the Registrar-General, can consider capacity and coercion, for example, and there are elements of protections on that in the bill and in other areas, for example, in the Registrar-General's work that they do around forced marriage. And so I believe that this amendment at best is not needed and at worst could have an unintended consequence for disabled people that I don't think the member or others would hope it to. And so on that basis, I wish to speak against that amendment today.
Thank you, Ms Duncan-Glancy. I now call the Cabinet Secretary to respond.
Thank you. These amendments would place a duty on the Registrar-General to ascertain for every application for a gender recognition certificate whether the person applying is subject to a welfare power of attorney or guardianship order, to have regard to the Adults with Incapacity Scotland Act 2000 and to provide information, advice and support. Under the Age of Legal Capacity Scotland Act 1991, a person of or over the age of 16 years generally has legal capacity to enter into any transaction having legal effect. The bill also already provides for a person who has an interest in a GRC to apply to the Sheriff to revoke a certificate on the ground that the applicant was incapable of understanding the effect of it, or that the applicant was incapable of validly making the application. The yes, of course.
Ruth Maguire.
I thank the Cabinet Secretary for taking an intervention. I wonder if she would respond to my point that those processes are available at the end rather than at the beginning, and comment on what safeguards are available at the beginning of the process.
Cabinet Secretary.
Well, so the Registrar-General can also make a similar application to refuse an application on the grounds of incapacity, and that would be at the start of the process. And it's right that it would be for the Sheriff rather than the Registrar-General to determine whether a person had capacity to make an application based on the evidence, because they would be able to gather that evidence, unlike the Registrar-General. There are other persons who could validly have an interest in a certificate in the circumstance that the person obtaining the certificate may not have capacity. These include, for example, a person with power of attorney, or a guardian, or a person authorised under an intervention order under the Adults with Incapacity Scotland Act 2000 who acts for the person obtaining the certificate. The 2000 Act makes provision about decision-making on behalf of those lacking capacity, generally in relation to applications to the Sheriff or Court of Session or to the Public Guardian. The Registrar-General does not have functions in relation to proceedings under the Act. Therefore, it's not clear what the relevance would be to the Registrar-General's functions in this context. Provision already exists in the bill to allow for GRCs to be refused or revoked on the grounds of the capacity of an applicant, whatever their age. And, as has been set out, National Records of Scotland will provide guidance to applicants on how to make an application and the effects and consequences of obtaining a GRC. These amendments also require the Registrar-General to make available information, advice and support, and to communicate this in an inclusive way. There is already a requirement on the Registrar-General to publish information on the process and the effect of a GRC, and I agree that this should be done in an inclusive and accessible way. The National Records of Scotland already have a clear commitment to making its websites and resources usable and accessible, and this is set out in its accessibility statement. So I don't think these amendments are required, and I would urge people to vote against them.
Thank you, Cabinet Secretary. I call on Ruth Maguire to wind up and to press or withdraw Amendment 34.
Thank you, Presiding Officer. I'm pleased to have got on the record my concerns about adults with incapacity. I think based on what the Cabinet Secretary has said, and particularly around the importance of inclusive communication around the support, that I will not be pressing these amendments.
Thank you, Ms Maguire. Ms Maguire is not pressing Amendment 34.
Ruth Maguire.
I just wanted to be really clear. I was not making a point about self-identification in itself. I was just pointing out the difference between the two systems and asking how evidence would be proven. I mean, people may have a concern that folk will be wrongly accused. I get that prosecution is the business of the prosecution service, but law is our business, and we need to be really clear what we're legislating for. So I really was not making a point about self-ID. I was talking about your amendments.
Jamie Green.
First of all, I didn't refer to the member by name or glance in her direction in general. That comment is not directed at any individual members. I'm making a point, though, and I think it's fair to say it would be unusual for me not to point out that there are members in the room who do not agree with the change that the legislation